support services. Importantly, he has been appointed as a special master in 3 Bay Area County Superior Courts by special appointment, has provided consultation services to the court judiciary, participated in a colloquium on advanced business valuation issues sponsored by the California State Judicial Council, and made instructional presentations to both accounting and legal professionals or professional organizations on business valuation issues. And really he has participated in over 750 valuation engagements. So we're very lucky to have him here tonight. So without further ado, I'll turn it over to our 3 speakers. Thank you.
Great. So, you know, sometimes the air conditioning gets kind of loud. If you can't hear me, especially in the back, will you let me know, or any of the speakers? I'd appreciate it. So, transition planning for law firms. We're going to start off with a little bit about why we're here. The State Bar, I don't know if any of you have been to the website lately, but they're really worried about how we attorneys are getting old. And if you look back at 1991, this is a chart I got from them, 14% of attorneys were 55 years or older. In 2006, 35% of us were 55 or older. And as of 2011, we're at 48%. Perfect, thanks. 43% of attorneys are over 60. So we're getting to be an older sort of group, and that's causing the State Bar to worry about, among other things, our competency to continue practicing, and also what's going to happen if we don't properly retire. Just another tidbit is that, you know, a lot of us are thinking about just continuing working for a long time. Well, the State Bar shared with me that at the age of 65, 5% of people, let's see, yeah, people age 65, around age 65, have lost about 5 to 10% of their cognitive abilities. And by the time they reach 85, they may have lost 50%. So when we have attorneys who are starting to work well into their late 70s and 80s, this is what the State Bar is concerned about. So why are we working longer? Some of us just enjoy working. I know folks who just tell me they're just going to keep working until the day they die. They like it. Some of us don't have an exit strategy. You're solo and you haven't really thought about what you're going to do with your clients. Or maybe you don't have the retirement funds. All of these things can be dealt with by planning. So as I said, one of the issues that the State Bar is worried about are our ability to continue practicing. What happens if we, and this could happen to anyone, unexpectedly have an illness, can't practice, an accident, or die. And they're worried about closing these practices. In 2012, I think the State Bar actually had to take over around 90 practices, solo practices, where there had been no planning done, and those attorneys either died or were unable to continue practicing. And so that's not really happy for your clients, it's not happy for your estate, and it's certainly not happy for the State Bar. So when we say we're talking about competency, you know, this relates to the rules that we're all bound by. Rule 3.1110 says a member shall not intentionally, recklessly, or repeatedly fail to perform legal services with competence. It means that we have to be diligent, we have to apply learning and skill, and mental, emotional, and physical ability. So even those of us who have many years of experience and may be very knowledgeable may have run out of patience with our clients, or just not really be interested in coming in anymore, and that becomes an issue, and the State Bar is seeing it. So we're going to learn a little bit about planning. We're going to learn about how to create a valuable asset out of your practice. Mike's going to help us with that. It's interesting that until a few years ago, solos didn't have a lot of choice but to close down when they were going to retire. It was considered unethical to sell the goodwill in your practice. So the reasons being that clients have a right to choose their counsel, and that there is the risk of losing client confidentiality. But what that meant was that the folks who were at firms, who were bringing up junior partners, they were able to get value out of their practices by essentially bringing in the young attorneys and selling to them. But if you were a solo, the day you retired, it just all went away. And then, so what happened was we have this new law, new law, and it's Rule 2300 that explained how we can go through the process of selling if you're a solo attorney or a small firm attorney maybe. How you can go through and sell your law practice and get some value out of it, and is now recognized as an ethical activity. I was supposed to let you guys know that we hope that you'll interrupt with questions as we're going through and not save them to the end, because we're going to be covering a lot of material, so please feel free to interrupt. And at this point, I'm going to ask Mike to come up and talk about how to build value in your practice, and then how you're going to sell it and get that practice out, get that value out.
So the first thing for me to measure, or if I give you a suggestion, is you have to figure out, are you in a practice or are you in a business? Businesses bring value. I don't pay too much for practicing, right? So if you're operating, as I mentioned here, in a lifestyle mode, or what we call personal goodwill, what I want is I want the value to attribute to the book of business and I'll say the concepts of the firm and not you. The more that you can transfer this, that it's the firm providing businesses and not you, the more value I can contribute to it and help you sell the business. And as you noted here, there's a lot of small law firms are out here. And the biggest measurement, or the thing we suggest you need to measure, is this. I will tell you, I've been doing this a long time, 30 to 40% of your revenues should go to labor. Okay? And another 30, 40% should go to occupancy costs. So I'm looking for you, after you pay your occupancy and your labor, whether it's a paralegal or a legal assistant or the professionals or whatever, I'm looking for you to have, I'll call it a contribution margin, somewhere between 40 and 55%. So I want you to go back and figure this out for you. Just go do it in the last 12 months, take your total revenues and subtract those two costs. And it's not paying you, it's paying the labor and the other employers and the overhead, the occupancy, okay? So if the more you are towards 55, obviously the better you are. And if you're below 40, if you're only doing 30 or 35% profit margin, then I don't think you're at the mean or median of what law firms yield. Yes, sir?
I guess I'm mathematically challenged.
Okay.
It seems to me if you're just paying the minimum for the labor and the occupancy costs, 30% each, that leaves at most 40% for your operating costs. How do you get to 55%?
I mean, the big national firms like the accounting firms like Ernst & Young, they operate at over the 50% contribution margin. It's the more, I'll say the larger the revenue base that shares the overhead, and it's significant. It's possible. That's why the national firm partners make so much money. They're making 55 to 60% of the revenues are going to pay the partners because they are getting the more exposure as revenues of value employed.
Well, then they must be paying less than 30 or 40%.
They can be. Yeah, I'm just trying to give you some measurements. Okay. So the point being is, I would take a solo practitioner or someone in an office, if you have 3 or 5, you've got to be over 35. And the more closer you get to 50, the better I like it. Okay? So that's maybe the bigger message. And what I'm trying to do here is I'm trying to compare you to your peers and what's possible. For a reason I'll explain in a second. Okay? Thanks for stopping. And people who don't practice when you've been to a large firm. I was the managing partner in the Ernst & Young office in Walden Creek. And all I did every morning, I came in, and when I came in at 8, I had to have how many chargeable hours we had yesterday for the office guys. There's 70 guys working. I want to know the total chargeable hours from yesterday, added to the day before, cumulative totals, where we were that year. If that number was sufficient, that we had enough hours charged, I could go home. Because all the rest of it would work out. The revenues were there. So these are the metrics people use about utilization. There's 2,080 hours in a chargeable year. And maybe you do or don't keep billed hours, but if you're going to try to sell your practice and you're going to have some guy like me look at it, I want to know how many hours you've been billing charged to clients. And I want to know the relationship with them to 2008. So I would tell you that most partners in larger firms, they're looking to get 1,200 hours, 1,400 hours charged maybe. The staff should be at 2,300 if things are working out right, but they sure ought to be at 1,800 or 1,900. I'm looking for large chargeable percentages to the staff, and a partner maybe in the 1,200 to 1,400 hour range. And again, I'm telling you these things so that you can go home and kind of measure where you're at to what the expectations are for a reason I'll explain in a second. So that's utilization, and then there's the next concept is called realization. So I charge 1 hour to do an estate work, Oliver, for $400 into an account. If I could only bill $250 of it, my utilization, I make it easier for me. If I could only bill $200 of it, I have a 50% realization rate, right? And that's not good. The realization rate's got to be in the 88s, 89s, 90s, 85 is getting to me to be, at the bottom edge of acceptable. So the first thing I do if I said, look at your practice, I'd try to figure out your profit margin, or what I call contribution margin, your utilization and your realization rates. And all I'm now doing is I'm pegging you against what I think is the standard. And that's what I'm doing here when I say compare your practice to subject to the market. And the biggest issue, are you better or worse than the mean or the median? Most likely the measurement is the median. It takes out the outliers, and I'll show you how this all works in a second. Okay, so now that you've shown me your statistics and how you operate and how I think you're either better or worse than the median, it's time for me to figure out what the value or how you might be able to sell a book of business. So the purchase price is going to be usually established as a percentage of revenue, cash basis revenues. So let's say the firm billed $800,000 last year. The whole book of clients for your 4 to 6 man firm. So now we're going to pick a metric, something like 0.6, 0.5, 0.7, 0.8, maybe 1, I doubt it. Obviously, the higher the metric, the more the value. Accounting firms sell at about 1 times revenue, on a basis that I'll explain in a second, because we have a recurring revenue base. The tax returns are going to show up every year. I have to kind of almost screw up not to have them come back. So I'm going to say that's probably more than you can expect. Now look around the room and look at the practices. I assume an estate practice probably would have a higher metric than a criminal defense lawyer. Okay? Because at the end of the year, when he gets everybody in or out of jail, he's got no clients again, right? I guess. So the point is, the more recurring and the more contractual, the more affirming that I know the revenues are going to be, I'll bump the metric up. And if you're better or worse than the industry standard, I'll bump it up. If you're worse, I'll bump it down. And if you're a non-recurring revenue source, where you're having, if you can establish for me, I get 75% of my clients come from these 4 referral sources. And they're good ones, and they're going to continue. Well, okay, I'm convinced, and up goes the metric a little bit. So all I'm trying to do then is determine the metric as a percentage of revenues. Most of these transactions are done on a contingent basis. Nobody will pay you cash up front at the value that we're going to estimate here in a second on my $800,000 practice. I don't think. I'll show you an example too about how I might do that, but it's unlikely. So it's a contingent purchase price, and there's usually a floor and a ceiling. So let's go back to my example if you can do the math in your head. Let's say it's an $800,000 practice. And we established that the right revenue multiple is 0.6 times the revenue. That's a value of 480. We all got that math, okay? But here's how I'm going to pay it. I'm going to pay it over 5 years. And so what I'm going to do is I'm going to take the 0.6 and I'm going to divide it by 5, 12.5%. The buyer will give to the seller 12.5% of the revenues that come from the clients that are on Exhibit A. And you now list them all. Anybody who ever did leases with you, now or forever hold your peace on Exhibit A. So now Exhibit A happens, the client comes, he sends in 10 grand for support to Oliver. Oliver owes me 12.5% of 10 grand. He owes me $1,250, right? And if they come again, they come again, they come again, they all, you know, for 5 years. In theory, after I've done that for 5 years, I've paid 0.6 times the revenue. 5 times 0.125, right? Yeah, that's how it works. So now that sounds all wonderful. It's actually very low risk to the buyer. Because I'll sign up for this tomorrow. You're only going to pay if they come. So this, have you ever had your dentist send you the postcard that says I'm retiring and I found the world's greatest dentist from the University of Nebraska, he's taking my place? This is what they're doing. Okay. They're telling you, please stay in the next dentist. He's not going to get a cut. He doesn't write that. That's the sentence that's missing. Okay. And then maybe you should. That's fine. You got a client base. All right. So now, the next term is a floor and a ceiling. In my opinion, if you're a seller, you want to put in a floor. You know, you guys, right now, you kind of think Mike's a pretty good guy, but I'm really not. And so I start treating your clients badly, and I'm rude, I'm obnoxious, I can't do the work, I'm not technically competent, and they all go away. And that means, shoot, you picked the wrong guy. Okay? So what you need to do is put a floor in it. So at this 480 number we talked about, maybe the floor is 150. It's like no matter what I do, you owe me 150. In fact, usually at close, that money is paid buyer to seller at escrow. It's a deposit against the contingent payments. So that way there, that protects the seller a little bit if you pick a bad guy. You know, to some extent, if you pick a bad guy, I don't feel too sorry for you, because I'm cold-hearted that way. But the theory is this is to protect the seller from buyer bad behavior. On the other hand, if I'm the seller, I might say, look, I'm going to pay you 12.5% of the cash receipts for the next 5 years, or whatever, 12%. But I am not ever going to pay you more than $800, because that's the last I'm going to do. That's probably, I don't think that's fair. My own opinion is if somehow one of those clients stays, and you get a $1 million verdict out of it or something, you should pay, and the guy should get it. And I think it's best, in my opinion, if there is no ceiling. But sometimes buyers want a ceiling. I don't think that's a very good idea. I mentioned to you about the deposit. You see how that works. So if the first year's cash receipts were $600,000, you at 12%, I would owe you 72 grand. There's 150 on deposit. So now you have $8,000 left, or $78,000 left to the next year. And you just work off the deposit until payment happens in the third year.
Are you saying the deposit is different from the contingent price?
It is part of the contingent price, but it's just there as a minimum no matter what happens. So if you now say, here's what I owe you, minus what's been deposited, I don't owe you any more yet, but eventually by the third year you start getting a check. Okay? So then I believe if you're in a little bit bigger firm, you have 6 or 7 or 8 people, and I've now looked at the firm as a buyer, and I've identified that there's 3 key lawyers and a paralegal, right? But I think they're terrific. I would basically condition the purchase that 2 of those and the paralegal have to stay, or it's no deal. And so now, there's no escrow, no close. It's a condition to close. Out of A, B, and C, 2 of them have to stay, and the paralegal has to stay.
For
so
how
now,
long?
Probably at least a year. It's all a matter of negotiation, and this is, in my opinion, how it's done. In my opinion, the best thing that the seller can do is, I agree, and let's do this. On top of this payment we're already making and the multiplier, let's agree to put together a bonus pool. I'm making it up. 50 grand, 80 grand, 100 grand, I don't know the number. But we're going to put a $100,000 bonus pool in. I'll put in 50, and this buyer should put in 50. And now you tell the three of them, if you stay for X year or 18 months, the three of you will participate in the bonus pool based on probably a subjective determination by the buyer and the seller. And the reason I like buyer and seller is now that the paralegal is not allegiant to the seller, and they're not allegiant to the buyer, they're rooting for both of you. It's good, in my opinion, to be on the same page here and not have one of them overtake the other for influence. Is that the right word? And that's called a stay put or a retention bonus. And that becomes part of the document of the asset purchase agreement. Now, back to you. You sold, and do I need your assistance to transition the practice? Yes. Okay, so probably for the first 6 months, you have to give me 20 hours a month, maybe 40 hours a month for the first 6 months. And I'm not paying you for it. It's in your best interest to do this. Okay? But in the 7th month, I shouldn't need you as much. So if I want you to come to a meeting with an important old client, and it's going to be a 3-hour meeting, then I owe you 3 times $150. And if I really need you, I'll call you, and I'll pay you something, and we'll go to the meeting and root for the new team, and tell the guy, yeah, Mike and those guys know what they're doing. This sounds like a good plan. That might be the old client might really like that. Okay, so I'll pay you. So for transition assistance, there's some I'll call it free. It's in the purchase price assistance, and then there's some paid after some negotiable period of time at some negotiable rate. But it's something like that. And then you absolutely have to sign a covenant not to compete, of course, and you'll need to get paid for that. Now, here comes one last bigger concept. These payments, are they going to be ordinary income to you and tax deductible to the buyer, or are they going to be capital gain and not tax deductible? All negotiable. Just kind of depends. So if you think I'll pay you more if you let me deduct it. It'll be ordinary income to you. In theory, the seller's income is going to go down. You're old, you're going to get Social Security. It's time to put your feet up a little bit. So your tax rate's going down. Maybe it's okay that your ordinary income. Most likely it's some combination of both. And then lastly, these are asset sales. If people do transactions here in the room, if you know about an asset sale, and here's how it really, really works. The value you're practiced in my example, this $800,000 value, is going to be $800,000 if you get it, well, I'll say it, 0.6, 480, plus the seller keeps his cash, keeps the receivables and the unbilled work in progress. Okay, but you have to pay off all your liabilities on the way out. So the equity value is the payment, contingent payment for the book of business, plus that formula. Does that make sense? We'll take the CPA test next week. So I brought 2 actual examples here. This one I'll mention to people who are in a larger firm, but everybody does their taxes and reports their income on a cash basis, right? Okay. That's not what your accrual basis capital account really is. So the value, like in the large international accounting firms and law firms, when the people retire, they get their accrual basis capital account paid out over time. And to do that, you would do this kind of example, which I think the Bar Association has got a book for you or has the slides. So here, this is just taking the cash basis. You now add the receivables and the work in progress. And you got to put a tax effect in there on the difference of them. Determine the accrual basis net equity, multiply by your percentage of the firm, and that would be your accrual basis capital account on the way out. If that makes sense. So we don't need to do math here tonight. And then the last point I'm going to make is this one. Now we mentioned in this $800,000 book of business that I would pay contingently over a period of time, right? So now you go, no, Mike, I want cash up front. Well, here's the calculation. So in this one I have a $750,000 practice, book of business, that I'll pay 0.8 times. So I valued it at $600,000. You can see that math. And I want a 16% rate of return on my money. Now, let's see if that makes sense. If you were going to loan me money tonight on a second trust deed at my house, I'm creditworthy, so you'd probably charge me 8, 9, something like that. If you give your money to Merrill Lynch for a while, tell them that get the stocks going, come back in 10 years, they're going to get you 10, 11%. If you buy a building, you're probably going to get a 15% rate of return, something at that rate. now I'd like you to invest in a small local law firm. It's riskier than those things. So you're going to want a 16, 17, 18% rate of return because I have alternatives with my money. So if you present value at 20%, I think is what the payments of $600,000, I'd only give you $310,000 up front in cash. So if you really think about it, now would I take that risk? No, because I don't think it's that easy to transition in professional practice. But the point is a value of $600,000 present value is about half. And that's a real mathematical financial fact. So to be asking for a large cash payment at retirement is not realistic. Okay,
Just a few more comments on bigger firms and how they're structured. So some of the firms have mandatory retirement policies. And I just want to alert everyone that the ABA has said that they should, they're disfavored, let's just put it that way. And the EEOC also, particularly in relation to accounting firms, is looking at mandatory retirement policies. There's actually, it is still, at least, and maybe even James can address this, my understanding is it's still okay to have a policy for owners, right? There's a test, Clackamas Gastroenterology versus Wells, which talks about the difference between what an owner and an employee is. So that junior partner that really has no equity or no interest in your firm is not a partner, and not an owner. And that person really shouldn't be subject to a mandatory retirement policy. Sorry, I just lost my train of thought. Oh, but what the ABA is proposing, because they are addressing this issue, is look, there are ways you can structure this as far as performance reviews or making sure that there are productivity standards, and that's what you should be looking at. So a lot of the firms, the larger firms, to make sure that their older partners are moving out and making room for the juniors, are still using these mandatory policies and should be looking to something a little bit different. And they're also, the ABA's suggestion is an incentive to step down to the older attorneys. And then Mike actually talked about non-competes. And so we do have a rule that basically says they aren't permitted except in a few situations, and that's part of an employment agreement or your partnership agreement, or if a member's retiring and it is accompanied by a payment to help them retire. Those are permitted.
Is there any movement to just simply change an ownership structure at the bigger firms to just change what those senior partners are doing so they can still be owners and have less responsibility?
It's an interesting question, yeah. So a lot of some of the larger firms are looking at different ways. So for example, when you look at incentives, it might be that these older attorneys are the folks that really want to keep working, right? But maybe they don't want the pressure of having to go get clients and do billable hours. So if you give them an office and some support staff and ask them to mentor, or ask them to go do pro bono on behalf of the firm, these are the sorts of things that keep them active, keep them working on new projects, and in a way, it can be a win-win. So especially the larger firms that can support that sort of thing are looking at those sorts of programs. Yeah. Okay. You want to talk about this one? We're talking about Rule 2300, sale or purchase of a law practice. Do you want me to?
No, go ahead.
Okay. All right. So as I said before Mike started, there's now this new rule that it's not super new, but newer, that explains how we can now sell for the solos who will be selling to a third party, how you can do that, and what's required. So the first step is, and just let me back up for a minute. This rule is basically the same whether the member dies or whether just becomes incapacitated or disabled and can't practice any longer. There are some nuances, but it's essentially the same. You have to give a notice to the clients and let them know, and ideally it's 90 days in advance. Let them know that there's this change coming, let them know who the new attorney is that's going to be coming on. Give them the opportunity to come take their file. They still have the right to choose other counsel, so they can take the file with them, take the case with them. But that 90-day notice is important. It can be tricky, particularly if someone's died. So in that case, if there would be prejudice to a client because an attorney hasn't acted or isn't going to act while waiting, the attorney can act during the sale. So that attorney might be the purchaser. It might be someone who stepped in if there's death to try and keep things going. But so this 90-day period is kind of, it's tricky and you want to watch that. If after 90 days you haven't heard anything from the client, they're assumed to have consented and the new attorney can start working. There are no partial sales, meaning the entire book of business has to be sold, okay? Now, the only exceptions, and that is to keep people from picking and choosing and trying to get rid of the difficult clients that we don't want to deal with. So the exceptions are if the purchasing attorney has some sort of conflict, then obviously you can either sell the client, recommend the client goes to someone else, or retain that client. That would be one situation. Or if the selling attorney really has a very special relationship with a particular client or a few clients, they might retain them. Or it might be that those matters are sort of different, not within the normal scope of the practice that would be sold, so it doesn't make sense to send those over to the purchaser. In that case, they can be kept. Did you have a question? The purchasing attorney can't raise the fees just because of the purchase. However, if their fees, for example, are normally, so much higher, that would be permitted. The sales are still subject.
I don't understand that. They can't raise the fees, but if they're normally so much higher,
So
it's
just
okay?
just because you're buying so for example, just because you're bringing in these clients, and maybe there are some clients that you don't really want, that you're getting as part of this package, you can't raise your hourly rate for them.
Yeah.
But if your hourly rate, if you're buying and your hourly rate is, $4.50 and I'm selling it at $4, you could bring them up with proper notice to your.
So you gotta treat people evenly.
You gotta treat
Can't
people
pick and choose. Is that the idea?
That's the real concern here, is that there's picking and choosing, and that some people just get abandoned or lost, right? And now they don't have an attorney, they can't find a new attorney, they thought they had someone, and you don't want this difficult person, right? That's what they're looking at. The rules 3,300 and 3,310 about avoiding, adverse interests still apply. One of the tricky things here is maintaining client confidentiality when you're selling your book of business, because the buyer wants to know what they're getting, right, for their money. What's in this book of business? What kind of cases are there? Are they good? Are they losers? And you can't really, you can't say, well, Joe down the street's got this and this guy's got this. So you can give basic information. You can generally describe cases. You can sort of describe what the billing's been, but you have to maintain the client confidentiality, or you have to get permission from the client to share this information. And then, of course, yeah.
How detailed do you have to be in your notice to the clients about who's buying your file?
Right. You have to tell them who that attorney is, right? And I don't know that you have to do too much more than that, but I guess if you want it to be a successful sale, you're going to explain why this person is more qualified than the other person down the street and why you think this is the right fit.
Or the
right?
kind of work they do that might have conflict with your client.
You probably would want to, if they are going to have conflicts, yeah. You would want to describe absolutely. And so that's something, when you're trying to figure out who you're going to sell to, well, on one hand, you might be looking at the finances and what the offer is. On the other hand, you want to make sure that the person you're selling to is going to be able to handle your cases and that there aren't a whole lot of conflicts. And you don't want to be you don't want your clients to be lost for that reason.
Are you technically selling the file, as you mentioned, or are you selling whatever it is you're selling at the firm?
What you're selling is goodwill, and that's what you weren't allowed to sell
I get that,
before.
but you're not selling that kind
You're
of
selling
file.
intangible asset value,
Well,
not necessarily goodwill.
okay, that may be.
That's right.
You're
And
definitely not selling a
You're not selling
file,
live files.
okay?
Right,
Because I don't control that, right?
exactly.
The client can choose where they're going to go, right? So I've got projects in the works.
So your letter doesn't say I'm selling your file to X firm. It says I'm making this.
It says I'm
transition-
retiring.
Making this transition.
It says I'm retiring, or I'm, it depends on how, you might be merging. It depends on how your deal might be.
I was going to
going
ask you
together.
that. Wouldn't a merger be the more ideal way to explain it? Because you'll kind of merge with someone, kind of let them take over those files and those people, and then you'll just edge out.
So that's so a merger isn't a bad thing, but that's a different creature, right?
Mhm.
Then you're going to stick around and you're actually going to be working.
For a
Right.
little while.
Not very long.
Well, and that's right. Well, what's the real plan, right? Are you really merging? I mean, to go back to Inga's question, so we now see partners emeritus, right? Who or partners who now become of counsel because they want to stay part of the firm, but they don't really want to be too involved. Well, are they still, if you're merging, are you really going to hang out, or are you just there to sort of shuffle the folks along?
Maybe it's an easy way of saying is I'm semi-retiring into part-time work, and these are my partners who are going to be taking over who work full-time, but I'm still around if you want to see me, and that way it makes the transition a little easier, and then you go from your semi to
a
your
more
out.
important letter than this.
What?
This letter is very important.
Yes,
And
it
it has to
is.
be well written, thought out, and carefully said.
Are you guys going to talk about any successful transitions like that have happened around here?
In law firms?
Yeah. Or solo?
I know of two.
you know.
I know of two.
Are you guys going to talk about it as part of the presentation?
That's how they went, just like I told you, a contingent purchase price on the percentage of revenues of the clients on Exhibit A.
And did everything go successfully in both
Because
of
you talked
those
it all out in front. I don't
situations?
mean to get in front here, but yeah, because we talked it out. And what you want, in my opinion, is two happy people. A happy buyer and a happy seller. That's terrific. You
So
know,
who's hooking up the buyers and the sellers?
I don't know. Usually you might even know who your best competitor is. You know, or it's somebody who practices, in my opinion, in your field, specialties. I would like.
And somebody who's probably younger than you and wants to keep going for a longer period of time than you do.
Makes sense.
And would rather pay something for something existing than have to go out and market and advertise
Particularly
and
if I
find
have
brand
excess
new.
space, if I have more space in my office, I don't need your receptionist, I don't need your office, I don't need your computers, I got all that stuff. Well, I'll make more money on the same set of practice, same book that you did. My margins will go up. So it's accretive to me. I'm very interested.
He's interested.
Call him an accountant.
When we talked, Mike, you were telling me you actually successfully, I don't know if you handled it or you were involved in it, it was sort of a 4 or 5 attorney merger. or
I've done 2 or 3
similar,
just
right?
to help some guys do it. Just because they asked me to. I kind of like my background. I do real transactions, among real living people that have real businesses and that kind of stuff. But to bring the same discipline to this is a very simple concept. And it is how almost all professional services, whether you're an architect, an engineer, accountant, or lawyer, it's the only way I'm aware of to transition to practice and getting paid for this thing for people.
Just to come back to your question though, if you're doing a merger though, that's a little bit different than a sale full out, right? So this notice, this rule is really about what you're selling. And a merger, because if it's truly a merger, you're not leave, right? You're not selling it, like they're going with it and you're building some big deal. And
Right,
there's-
but it might be subject to an agreement that when you want to exit due to retirement, disability, death,
Well-
et cetera, that the terms of the exit are kind of spelled out.
And
We did this on January 1st. In December, you sent him a bill from, what's your name?
Marty?
Oh, so from Mari's law firm, sent him a bill in December.
Mhm.
Okay, but the Buckman firm sent him a bill in January. I guess I understand the outcome of that,
Mhm.
right? It's because it's not for you anymore,
Right, right, right.
so we gotta explain that.
Whether we merged or sold.
We merged or sold, we did something.
Right, so
Right.
you want to be clear on what it is, and probably there's some sort of, every firm is going to have some, one would expect, some sort of retirement plan, or some sort, we hope, have some sort of plan for seeing the exit of the owners, right? So even, I mean, I guess it could be that you merge and you expect to be there for 5 or 10 years, and then something happens, and truly at the end of the year, you're now exiting, right? I mean, that happens. Okay. So just to, and also to your point, so we're talking about right now, people who are all living. If the member, who maybe was a solo, has died, well, we're not going to have some of these same problems, right? So the notice of sale, if the seller is alive, it will be prepared by the seller. If the seller has died or isn't able to do it, it might be a practice administrator, it might be an appointed member, or it could be the buyer. If the buyer is actually, the friend, or maybe it was the person that was sharing an office, right, who now actually has control of the files, that might be the person who's responsible for doing the notice. The notice explains the intent to transfer files, client's right to choose different counsel. We've talked about this. Who's got possession of the papers? The notice has to comply with advertising and solicitation rules, and then the 90 days. All right. So if you don't sell, or if you can't sell, maybe the member has died. We've got the notice of cessation or has become disabled, and that's required to go out by the Business and Professions Code. It has to go to clients opposing counsel. It goes to your insurer because they're really going to be interested in this if your files are sitting there and no one's watching them. And the Office of the Chief Trial Counsel of the State Bar. And again, it might be the personal representative. So this is the reason why this is so important to really think about these plannings and have your estate plan and a process around this. If you die and these notices are being taken care of, we don't know who's going to take care of them. We don't want to leave a spouse who knows nothing about the law trying to figure this out. Okay. Or your, sweet mate. So a few years ago, there's this new law about practice administrators.
Practice administrators. So who's planned for their death or disability? What happens to your fund? Everybody? One of the handouts is the agreement to close law practice in the future. Has anybody ever done one of those? Anybody? So
Wow, this is like scary.
well,
Because most of us want to close before we die.
right.
Even though we're in the death and dying business.
That's on the bucket list kind of down there or something. This is a great form. It's available on the State Bar website. I didn't put a citation on it. So
You don't have to, because you guys should have, I think you have a handout called resources. And you'll see that there's a link on there for that. It's the agreement to close practice. Okay. And it's available free from the State Bar.
It's actually a good template to download it, print it out, and look at it, because it goes through a checklist of what you need to do to close down a practice. This is a big help to the family. It's a big help to successors. It's a big help to attorneys that are going to have to step in and deal with the practice. One of the slides earlier was Rules of Professional Conduct, Rule 3-110, and there's been an argument made that you have to have a plan like this to fulfill your ethical obligations to your clients. You know, what happens if you die while you still have clients? What happens if you're disabled? What happens if you get hit by a bus and you can't practice anymore? The ABA, there's nothing in California specifically to it. There's some argument that 3-110 might apply. The ABA has actually talked about it specifically, that you really do have an ethical duty to your clients to plan for your this unplanned exit. So it's something to consider. As far as practice administrator, so you're disabled, you're an attorney, you're disabled, and you either have one of these documents or you don't. In order for a person to step in and administer your practice or take over your practice, the process is through what's called a practice administrator. It's found in the probate code. If you're alive and disabled, or if you're conserved, it's brought under probate code 2468. If you're deceased, it's brought under probate code 9764. Part of the materials is a petition, consent, order for the appointment of a practice administrator. And you can read through that because it cites the Business and Professions Code and the probate code as far as what you need to do regarding that. Under that code section and referring to Business and Professions Code 6185, it has all the powers and duties that you need to, as far as ability to take over the IOLA account, to take over the general business account. Has anybody here ever done a practice administrator representative? I for some reason I have a couple of them, and it's very interesting, but I'm going to sort of admonish you that when somebody comes up to you and says, hey, please sign one of these things, that you'll take over my practice if something happens to me, you have to give it some serious thought, because it takes a lot of time. You're running someone else's practice, and you don't know anything about the clients, you don't know anything about the business, or you might have been a suite mate or something, so you might know a little bit about it, but you have to deal with unbalanced IOLTA accounts. You have to deal with banks not releasing the business accounts to you as a practice administrator, even though you have a certified court order that says so. You get to deal with their employees. You get to deal with the debts of their practice, ongoing advertising, copier expense, all the normal rent things. So it's just, it's a lot of work, and you have to think about it. Yes?
I wasn't a practice administrator, but I was involved in the deceased lawyer's estate, and there was a practice administrator for the office files and the clients, and I represented the surviving spouse for the probate part, and we handled the collections and the financial stuff. So is that ordinarily the way it's done? And it seems to work pretty well for us.
Sure, it can be done whatever way you can work it out. The practice administrator has a lot of powers and duties, but it's also, the practice administrator can't be appointed if there's an estate without the consent of the personal representative or court order if appropriate that way. So yeah, you can mix and match duties and hopefully not too much overlap. Absolutely, yeah.
Well, and not to interrupt you, but I'm sure at some point, if you haven't covered already, you're going to get to just dealing with files. So that was a big issue because in my situation, the practice administrator went through and they wanted to make sure that all the active clients got taken care of. But if I'm an estate planner and I did a plan for somebody 5 years ago, is that a client?
Well, you have possession of the file.
Yeah, I got the file,
So it doesn't matter whether you're a client or not, you have the files.
right?
So especially on estate plans, you have duties not to destroy the files.
Well, that's why I'm hoping you'll cover it, because that was a big issue on ours. This guy had been in practice for 40-some years, and the widow's saying, what do I do with all these files?
Well, good answer, nobody knows.
And I certainly didn't know either, okay.
Right, well, I mean, go ahead.
Is there any distinction in the rules regarding if your like fee agreement says that after you complete your engagement, you the thing you've been hired for is complete and you no longer have any duties to the client, like you've terminated your client agreement. So is there any distinction in the rules regarding whether you tend to have this ongoing relationship where you're the person's life attorney even though you haven't talked to them in 10 years? Versus if your fee agreement always says, when I've completed what I said I do here, our agreement terminates.
Well, that's a cleaner way to do it. I mean, you're not attorney-client for life. I mean,
Right,
you
right.
have
I mean, that's how I do it in my fee agreement, but I don't think my clients actually really understand that that I'm trying to protect myself for liability purposes and not saying that you, thousands of people are still my clients every day of my life.
But I think that's really a practice management question about are you cleaning up your files? So when you finish that engagement, I know it's in your agreement, but then is there also a letter saying, no, really I'm done now?
Sometimes.
Right? And really the file, it's going to the shredder. You can claim it right now. You've got 60 days.
Well, I don't shred the files, but I think a lot of people now are scanning the files and noticing the clients that they're not keeping hard copy files.
And you decide whatever your process is, right? And then you live with that process. And so, I think estate planning is a little bit different. You've got special rules about your files. But, get rid of send the original documents back and scan the stuff and then keep it for whatever your time period is. And don't have 50 years of files sitting around for your spouse to do.
Most of the E&O carriers are requiring a document retention policy in your engagement letter, which says I'm going to hold your files for X number of years, and at the end of that time, I'm going to destroy them. So if you want them, calendar it, that 90 days before the end of this 5-year period, you get in touch with me. Now, that doesn't mean you don't also get in touch with them, it just alleviates. You have a contract that says they're responsible.
And with a practice administrator, you get to come in and deal with all the files. So you generally have to notify all the clients because you don't know about that specific agreement with that client. So you notify all the clients and you say that, sorry, your attorney's either deceased or disabled. I'm taking over his firm temporarily, but I'm not representing you. I'm just taking over his file to administer these to get ongoing clients, to attorneys to take care of their problems, or to let you know that you don't have an attorney. And you're available to come in, pick up your file, we'll mail it to you, whatever you do.
Okay, so what do you do with the files that are in the cloud? And you're not holding paper files anymore?
Don't know. I mean, I think you have.
What is it?
Put on a
Yeah,
justice.
Exactly.
The client file, paper portion of the client file belongs to the client. So I don't think you can just put it in the cloud and scan it and shred it without giving the client notice. This is the subject for this, but
What if you
that's.
don't have paper copies? What if it's all been done digitally?
Because more attorneys are going just to paperless offices. But then you inform your client in the engagement agreement of that, and they probably have a right to come and get a digital copy of the file, right? Do you have to keep it forever?
They don't know. It's all part of your document retention policy.
Well, you've informed them, right? That you told them, at least in the engagement agreement, that you're a paperless office and you're going to be shredding everything. And then,
Paperless, you don't have it. You
Well, no, because paper still comes in, right? And so there are those folks who, the paper comes in from,
Scans it.
and they scan it,
And they shred it.
and there's a whole process for doing this. You keep it for X number of days, and then you get rid of it, and so you never have a lot of paper. You now have it all online. And so that's your file then, and that's the file that your client's potentially entitled to.
So it sounds like the practice administrator just handles the files. So if you really want the person that you pick to be a practice administrator to get your practice, you also have to say something in your will or trust that you're leaving your practice to that person. Is that right?
Well, not necessarily. I mean, it would be helpful to have some direction. When you don't know, I mean, when you do one of these agreements, you don't know when this is going to happen. It's a calendar issue. I mean, you don't know when you're going to die or take a class. So you can't really list your files with your clients that you want to transition, unless you say, I want my whole practice to go. But that's sort of a planning problem, because then what do you do about your family? I mean, does your practice, does all the value of your practice go to the new attorney? Or if the attorney doesn't want you to practice?
Does the practice administrator sell your practice?
Yeah, right.
He can do.
Yes.
He can also, or she can also buy it. Could be.
And practice administrator can represent your clients with all the normal consents and notices, if appropriate. The practice administrator can locate other attorneys to take over specific cases and farm everything out. And in fact, that's the whole idea, is you have to make sure that everybody all the clients are being represented. So
How do they get paid?
okay, the practice administrator gets paid or can get paid from the first source of the practice. The second source is the estate of the deceased attorney. You can't get paid without court order. It goes back to the probate department on petition for compensation. If you're doing this, keep track of all of your hours in detail. That's really the only way you're going to get paid. Cost you can pay yourself once you get it hold of the attorney's account. You can pay for costs. You can pay for employees. You can pay for rent. All of those things. But you can't be compensated without court order.
What if there's no probate?
You don't need a probate.
Oh, okay. But you still need a court order to get compensated?
Yeah, you go through the probate department whether there's probate or not. If there is, you file it within that number. If there's not, you just do a what number. It's just on that form. It's just a petition to a form.
Is there like an association of practice administrators that you can go to?
No. Yeah, I think I'm the only one in the room. So there are others that do it, but it's usually. I got it just because I generously signed one of these things. So I had a departing attorney, and then I read it after he died and said, "Crap." Now what do I do? So that's how I got started. So
And then you ended up liking it because you still do it.
Well, yeah. I don't put my shingle out there saying, send me your dead. But it's a process, and it's fine. Although, if you don't do probate work or contingent stuff while you have to sit around for a while, you don't want to do this, because I've been doing this guy's estate for 2 years. Not getting paid. So, not that, he was an office mate and a friend, and his spouse is a friend. So I'm not worried about that. But it's not something you want to build a book of business on. And also, you may end up at the end of this, like this one, and there could be nothing left. It's a marginal estate, especially somebody that might be slowing down in their practice. They don't have a big work in progress or accounts receivable, and there you have it. So it's still a lot of work. On this one, I have an unbalanced IOLTA account, and I still don't know what to do with it. I sent notices out to every client, that every file I could find, even the files that were in archives in Long Creek, and said, hey, if this guy has any of your money, let me know. Nothing back. So
Nothing from anybody.
nothing. So I'm going to petition in the probate case for instructions, and I narrowed it down to, about 12,000, and just give notice. And I haven't done it yet, so we'll see what happens.
Oh, so will that money just go to the state bar? Or
I
we don't know yet.
don't know. It will probably eschew to the state, I think. But I just don't know.
So haven't there been attorneys that died though and no practice administrator was appointed and like nothing happened because nobody did anything?
The state bar used to come assign attorneys to do it.
So what happens if you don't have a practice administrator? There is a process. It's very similar, but someone has to petition the court, or the court petition can do this on its own to appoint someone. And it's a lot of the responsibilities are the same. I think a key difference is the payment, right? That I think the practice administrators can be entitled to compensation, and I think the appointed members can also get compensation, but it's a more cumbersome process.
I think that's right.
Right?
But the powers are about the same. It's under the Business Professions Code 6185 has all of the different powers, and there are quite a few. And then even by agreement, you can add some powers, which helps. And you really need that in your order of point sheet, because that's what the banks want to see. One thing before I forget, which I forgot 3 times already, please, somewhere put your passwords and logins. I mean, you talk about your stuff in the cloud. Well, so how do I go find that? I don't know the answer, because the whole idea of passwords is nobody gets to see them. But you got to put them somewhere. So have a working checklist of maybe you have some staff. So have a letter or something that says this is where my stuff is. You can keep it locked, but and keep it updated. But it's just a nightmare trying to get into, and everything's password protected now. Your accounts, we have just straight online accounts that with no paper, even down to your iTunes and stuff like that, because some people have valuable collections of music that they pay a lot of money for, and so far Apple will not recognize trust or decedents estates for passing it on. You got to have their password and their user ID in order to get it. So if you don't take anything else away today, passwords, put them down somewhere.
So do you have to have an attorney do it, or can you have a family member do those things?
You're going to need an attorney to go in and look at files and figure out what's happening. I mean, a non-attorney could handle with their proper supervision the trust account, for example, but you need an attorney looking at the files.
You could put an authorized signer on that account.
Well, you can't have non-attorneys go look at client files.
That's
So
true,
sure,
but I mean, you can have an authorized signer on your bank account.
I think that's true, but the issue is if you're dealing with the IOLTA, you've got to make sure that one, you have to have a member who's responsible, and whoever's doing the administrative part, bookkeeping part, should be familiar with what's going on also as well as the attorney.
This isn't directly on point, but it ties to the passwords problem that everyone has. If you're not using a program that captures and deploys your passwords, they're wonderful. I use KeyPass. It's free. And once you get the hang of it, it will create impossible to remember randomized passwords that are 20 characters long. But you don't have to remember anything except the master password. Everything else is kept. And you can configure it so that it will just dump your username and your password into the sites where you want to have it. Magic. And then if you just leave the master password, whoever has that, you get everything. KeyPass. There are a bunch of them, but KeyPass is the one I use, and I'm delighted with it. It costs nothing.
Last.
Keep at least one password then.
Last.
You need
pass.
one.
Right, like that one. But the example here is about as far as a non-attorney helping, sort of like Mark's example, where you have a personal representative that might deal with some of the financial issues, and then the attorney can deal with parting out clients and making sure everybody's covered.
So, and I like to harp on, I'm not an estate planner, but this idea of a letter of instructions, which might be kept by the office manager, it might be something that goes to the spouse, that also will say, here's where you're gonna find this stuff, guys. It's not part of the practice administrator agreement. But, and ideally, you have the practice administrator agreement, and you had a conversation with this person who's going to take over, and they sort of are familiar with your practice. But if nothing else, there should just be a letter that says, here's where you find this stuff, right? Here's where the checks are. Here's where I put the bills. Here's where I've got my passwords. And it sort of helps get things rolling when you're not here anymore. Okay. I'm not going to spend a lot of time on this, but if you have a law corporation and someone passes or leaves, you have obligations to give notices to the state bar. Same for limited liability partnerships, so make sure you take care of that. And of course, if you're in a two-person partnership and one of you dies, you're not a partnership anymore. So you've got to do something. You want to think about that. So.
Everybody have an estate plan? Something?
Yeah.
Trust, will? You gotta have that. I mean, it's just so much easier. Oh, and specifically, especially if you have a trust, name your practice in your trust. So everybody usually has an exhibit A to the trust. So name your practice to go into the trust. And you can do the same thing in a will. Will not, you don't have to specifically name it, but in a trust you do, because if it's not going to be titled in the trust, but in order to have the trustee take over, you have to refer to it with the trust administrator.
So I'll just wrap up my note with this. I was talking to a fairly young attorney the other day, explaining I was going to do this presentation. He said, "Oh, when I die, what do I care?" And I said, "All right, Gary. You do, because you've got a spouse and you've got kids and you've got an estate, right? You want to protect that. You don't want to leave them with a mess. Yeah, you're done, and you may be done with the fun part of practicing law, but you don't want to leave a mess behind for anyone, and you do want to protect your estate for your heirs. So for no other reason, what we've talked about today is trying to figure out how you're going to get value so you can retire, so that you don't end up dying. We talked about how to take care of this stuff so that you can make a neat transition, if the unexpected happens, and how you can take care of your family. And that's why all of this ultimately is about taking care of your family. It's all really important.
So I guess that raises the question that part of what you dealt with and this whole presentation is about. If you wait, and even if you have the plan administrator, it does not seem like the surviving spouse probably got very much value out of that practice by that point. Am I correct on that?
Yeah, that's true. I mean, there was some, receivables that you could collect, but they
The
didn't.
intangible value's got to get recognized by the community up front.
Up front. So that's what I want to clarify, is that if you wait too long, somebody dies unexpectedly or incapacity, the value can just kind of evaporates.
Right.
Well, so what you should take away from Mike's presentation is that it's about building the business and then transitioning, right? That's where the value comes. So you're right. If you wait till the members passed, you've lost that opportunity, right? So you don't want to wait unless you really want to work until the day you die. And some people really love what they do. Okay, as long as you put the money aside to take care of the family.
So I need to understand more about your term tangible value.
Intangible value.
Intangible, yeah, since everything is intangible.
Correct. What you're buying in a book of business is customer relationship, assembled workforce, and the purchase price is not a tangible asset. It's not computers and desktop file shares.
Okay, so my guess is most of the people in this room here are sole practitioners or close to it. So no existing workforce to pass on.
Okay.
Right?
Okay.
So basically, it's the client relationships, right? Okay. You ever dealt with a situation where the strategy has been, I'm not really planning to take responsibility for any more cases, but I'm, keeping the phone number and I'm keeping the files, and clients who've done business with me before, I'm a state planner, who've done business with me before, when they call in, I'm gonna refer them.
So you take your will box and wait
Yeah.
for your clients to
And we'll see who comes in, I'm gonna refer them, and,
And hopefully you get a referral fee back.
Pardon?
You get a referral fee back.
Yeah, right, on a case-by-case basis.
That's a plan.
It's a plan. Has anybody done it that you know?
I can think of several. Yeah.
Okay.
How did it go?
Well, it did real well until the departing guy died and his son decided to take all the files and throw them in the trash.
And who do you hold liable for that?
The son
That only
and
works
the
in
other
estate
one?
work. I mean, that's only gonna work for estate planning, wills.
Yeah.
Yeah.
The only one.
Well, I mean, the only thing you.
No, we were co-handling cases until, and the old guy was just have 90% of the fee.
90% of the fee for co-handling
Do you have to have tail insurance when you quit?
Well, that's one of the things you want to try and get. It's not always available.
I would tell you, that's the other thing in my experience, if you have a merger or a sale, it is much cheaper for the acquirer to buy the insurance than just to buy a tail. You'll find that the insurance company will cover past acts and book the business for $15,000, $8,000, not very much. If you want a tail, it costs $150,000.
Ooh, I can share with that. The State Bar has a liability insurance policy with Arch, A-R-C-H. And if you've been with them a certain number of years and you reach age 55 and retire, you get your tail for free.
There you go.
State Bar's website.
But
Like free.
Companies offer that after 3 years or so.
After 3,
Yeah.
There is.
yeah, well, the state, the one states it, and a lot of them were older than 55, and I liked that the states was 55. And then if you're 56, you had to be there like 6 years, or they had a year and everything. But the idea, but I couldn't find anybody before 55. Give you the free tail, but the tail only costs like 2.5 times your annual premium if you need to buy a tail. Just renewed mine. Just read it.
so is your tail based on the most recent limits that you've had? or-
Yeah.
This came up, I asked in the family law section on this, and some of you were at a while ago, but if you do the plan for the referral thing, you have to stay active. Presumably mean you also want to keep the minimum, coverage in force, so you could do your free tail policy, and then you've got nice low limits, so your premium isn't much, then your tail policy is less too.
And then of course you have to disclose when you're getting those fee sharing for the referral.
Any other questions?
I just have, like you said, a lot of us are sole practitioners, and you said you've seen 2 successful ones. Do people really sell their practices? Is there a market for an estate planning practice that is out there?
I know someone who just sold one and did pretty well. I don't know the exact details, but I think it's more along the lines of what you're describing. It has a specific relationship with the firm that's taking these clients that are in a transition. But so the thing to think about is, okay, so you're a solo, and that's great. If you want to be a solo, that's fine. Well, what's the plan going to be at the end? Or are you going to close? Are you going to try and sell? Or is it worth it at some point to say, I'm successful and I have enough business, I can bring in a junior and develop something different, right? And plan to create that business. So now maybe either you're going to sell your business, or maybe you're going to sell it to the junior partner you brought in, right? And so the point being, again, thinking a little ahead of the end to come up with a plan about what that's going to look like, as opposed to, I'm not feeling well, I don't want to do this anymore.
Sure, that's why we're here.
Yeah. Hopefully, we all come up with a good plan.
The idea of a plan is to have a brother-in-law becomes a partner, and her daughter comes into the practice.
Generational.
Because we represent, you talk about getting rid of files and shredding files. We've got files that involve 3 generations of people. And we don't want to be in a position where we get rid of files because they regard us as a place to come. And
So you're gonna go into the warehouse business, to keep storing these files? Is that the next step? Is that the plan?
we've got analysis.
I suggest you talk to Bray about that.
Anything else? Because it's 6:01 and I know Mike's got a game to watch. And I wouldn't mind seeing a bit of it too. All right, well, thank you all